Y'all may be seated. Yes, sir.
And I'm moving for a mistrial. We raised a objection to lack of foundation. The case is Monroe v. State, 340, Georgia Appeal, 373-2017. It provides that the Honorable Court has wide latitude to admit demonstrative evidence, and the burden is on the party offering demonstrative evidence to lay a proper foundation establishing a similarity of circumstances and conditions. Although the conditions of the demonstration need not be identical to the event at issue, they must be so nearly the same in substantial particulars as to afford a fair comparison in respect to the particular issue in which the demonstrative evidence is directed. Further, experimental or demonstrative evidence, like any evidence offered at trial, should be excluded if it's probative value and the case goes on. But we emphasize the language that we stated. Your Honor, we raised a lack of foundation objection. Your Honor alleviated the state of their burden to prove any type of substantiality between the tests that Mr. Agent Grove, is that correct? Engineer Grove conducted and allowed the state to introduce this demonstrative. Once the bail is wrong with the jury, it cannot be unwrong. As we've said throughout this trial, Mr. Faust's defense has been handcuffed. The state has had free reign. It's to the point where our objections aren't even acknowledged. So, Your Honor, based on Mr. Faust's due process rights, violation of Mr. Faust's due process rights, and the entry of this exhibit, we would ask that the Honorable Court grant our motion for mistrial.
Thank you. Mr. Yalman-Chile, any response?
Your Honor, the foundation for the admission of the exhibit was laid. We haven't gotten to any of the questions as far as, what testing was done by Mr. Grove. We went through his qualifications. So, one, the motion is untimely, but even fast forwarding for the purposes of, and I would just note for the record, the only thing that's been displayed to the jury is a picture of the exterior of 160 Font Drive. So, but just fast forwarding a little bit, Your Honor, Mr. Grove received information. He tested certain things that were part of the theory as far as how the fire began in this case, and those are contained in the report. I would also note for the record that Mr. Cruz had an opportunity to review this PowerPoint last night in its entirety. He did not raise any kind of issue with the court prior to bringing the jury in. It's certainly, one, it's not even improper, but two, it's not grounds for
Mr. Cruz, you got Mr. Cruz, I'm going to let you respond because it's your motion, but you need to let Mr. Yalman-Chile finish his statements. Go ahead, sir.
I said that the evidence is not improper. I am making no personal attack on Mr. Cruz, but additionally, there are no grounds whatsoever for a mistrial based on this, which is properly authenticated and admitted evidence as a demonstrative aid, Judge.
All right, thank you. Mr. Cruz, anything further?
Absolutely, Your Honor. The Honorable Court, at the conclusion of court, allowed us the opportunity to view this demonstrative. The state, in multiple arguments, has insinuated that I have to run everything by them and then run it by the court. The law is the law. Regardless of how Mr. Yalman-Chile feels about me, the law is the law. This isn't anything personal. We're advocating. He says Mr. Faust did it. I say Mr. Faust is innocent. This should not be admitted without laying a proper foundation. It is admitted without a foundation. He's saying, hey, Your Honor, we're going to go through the questioning while we're showing the jury what the exhibit is. That's not the law, Your Honor. The law says that before they could present demonstrative evidence, they have to lay the proper foundation. That was not laid. The Honorable Court admitted it without even hearing us out on just denying our objection. So, Your Honor, Mr. Faust is not receiving his due process rights. I am requesting a mistrial.
Thank you, sir. All right. So first, I just want to respond, Mr. Cruz, to your comment that the defense is hamstrung, that the state has free reign. It is unfortunate that you are, as an attorney in this case, responding to the court's rulings in that way. The court certainly endeavors in every way possible to make rulings according to law. And it is unfortunate that you feel otherwise. That being said, you have asked for a mistrial. I'm denying that motion. There are no grounds for mistrial whatsoever in this particular moment. This is a demonstrative aid. It has been admitted into evidence, but demonstrative aids do not go back to the jury. The state is correct. They did provide you the opportunity to see that demonstrative aid. They did not have to do that, but they did. You are mischaracterizing the court's rulings, Mr. Cruz, in suggesting that this court is somehow forcing you to show the state your hand without making them do that. That doesn't fit any of the scenarios in this case so far. And that is a mischaracterization that is pretty frustrating for the court to hear. There are no grounds for a mistrial. The state has properly authenticated this particular aid, and the foundation has been laid. There has been no violation of 403. I find that this moment has not even suggested that 403 is even in jeopardy. And I'm making a finding, again, that the evidence is, at this point, not improper. This is a demonstrative aid, and I'm denying your motion. You may bring the jury out.
Yes, ma'am.